services of a consultant to create an advertisement or a particular picture or a piece of software, and assume since I'm paying this company or this individual to do work for me, I own the rights. I own the trademark, I own the copyright, potentially even the patent. Not the case. The only way copyright and trademark rights transfer is it was with a signed document, with an agreement, like an actual consulting agreement or some kind of assignment agreement that states that I, the consultant, transfer to you, the company, all of my rights, title, and interest in a particular work product.
So there's a different burden for copyright than there is for a patent.
That's right.
And if I'm working for someone full-time doing public relations, advertising, and I come up with a great tagline,
yeah.
It's a university, and I say, you know, study near but go far.
Right.
They own that. It's not mine.
That's correct.
Even if it's really great and they're going to use it all over and put on billboards and...
That's correct. From a pure copyright legal standpoint, without a piece of paper that states that the consultant transfers his or her or its rights to the owner, to the company, those rights stay with the consultant. Now, we deal with this issue all the time, and the owner of the company says to me, well, what am I supposed to do now? And you can probably make a very good argument that the owner still has certain rights in that work product. Could be an implied license, maybe it's co-ownership, because the company did pay for the work product.
Right.
But to say that the owner or the company owns it outright and the consultant has nothing, you can't really make that argument without that piece of paper.
Now, does a copyright and a patent and all these intellectual property concerns, they last forever and ever?
They don't.
They don't?
They don't. In the case of a patent, the average patent, the protection only lasts 20 years. In the case of a
Well, let's stay with patents for a minute.
Okay, sure.
That means that if I create some new pharmaceutical,
right,
and it makes you grow green eyebrows, and
right.
green eyebrows, everybody loves green eyebrows.
Yeah.
I have the green eyebrow market cornered for the duration of the patent, and then a generic can come along, take my formula, and start making green eyebrow formula?
That's exactly right. The law basically says, or I think the spirit behind the law is, we're going to let you monopolize a particular product or a particular invention for a period of time, and we're going to let you get as much bang for your buck during the protection period as you possibly can, and you can prevent others from commercially exploiting that particular patent. But there's going to come a point in time where society feels you've had all the opportunities to which you're entitled, but really we also have to look out for the better good of society, and that's when that particular, in your case the drug, would fall into the public domain.
Okay, so public domain, that's an important word.
Right. Public domain meaning, as you said, anybody can basically use the invention or the work as they see fit, without the original owner being able to compel any kind of license or any kind of royalty payment on any subsequent use of the particular product.
So let's give a concrete example here. I believe that Frank Baum wrote The Wizard of Oz so long ago that the actual work, not the MGM movie, not subsequent creations, but the actual work is in what you call the public domain.
Correct.
Right?
Correct.
That means if I want to write Part 2, Return to Oz, I could just do that without anybody's permission?
You can. I mean, as you said, there may be subsequent works that could prevent you from creating what we call derivative works or extensions of the original work. But if theoretically a particular work, a song, a play, a movie, an invention was in the public domain entirely, then other people could come and add to that, improve upon it, or create derivative works. That's why people pay us lawyers fees to figure out how we can maintain or how we can extend the protection as long as possible. And you brought up a great point, which is, by creating, for example, the same work but in color, or by creating slight changes to the original work, you can then extend the rights for derivative works, which in often cases has the same, but sometimes even broader scopes of coverage than the original work itself, thus providing the original creator with more protection for a longer period of time. But if something was to fall completely into the public domain, it's up for grabs.
There have been some famous cases over the years. I'm thinking particularly the Da Vinci Code. There was a case out of England saying that the work was based on an earlier book, Bloodline or something. And then there was a case, Harry Potter, the author was sued saying, well, you stole my ideas.
Right.
And what I'm noticing is that even if you're safe in the United States, Well, there's other countries out there that have some copyright laws that may affect us. Is that correct?
Absolutely. There's something called the Berne Convention, which is one of the early copyright conventions that basically states that as long as you're in a country that is a party to this convention, a party to this body of law, then your work is protected in all of those countries. So from the creator's standpoint, it's wonderful because you don't have to worry about people stealing your ideas in Canada or in Switzerland or in England or in Australia. Those are all ratifiers. Those are all parties to the Berne Convention. The flip side is also true, which is you could also have to defend yourself in all of those countries, which can be a very costly initiative. What's interesting, that's not the case with trademarks and with patents. Those are all protected on a state-by-state basis. So just because I have rights to a particular trademark in the US doesn't mean I have those same rights in the UK or in Germany. And you actually have to go about filing and protecting those rights on an individual country-by-country basis, which is extremely expensive. But especially companies, large companies with well-known brands, that's an important undertaking, which we've handled on many occasions, but it can be very expensive, very time-consuming, and very resource-intensive.
When you say state by state, just to be clear,
country
for our
by
audience,
country.
You mean country by country?
Yeah, no.
Okay.
The states, the United States is one big country, considered one big market. I meant country by country.
So these are all federal laws then that we're talking about with copyright patent. Are there any state laws? Is there a New Jersey state copyright law?
There is, I don't believe with copyrights, but with respect to trademarks, there are state laws. And what you see is sort of an outgrowth of the trademark laws. So, for example, a lot of advertising laws were born out of the federal trademark laws. So deceptive advertising laws all typically will fall under the same statute or the same body of statutes that apply to trademarks. So the lawmakers have seen use of a lot of IP having an effect in other areas of the law. And that's where the state laws typically kick in.
There's a famous line in a court that the Supreme Court reviewed one of the claims of false advertising, and the judges say, well, it's mere puffery.
Yeah.
That means that you're allowed to talk up your product a little bit, right?
You are. But as long as there isn't an actual untruth that's being told or too much puffery, too much grandiose celebration of one's product such that the consumer might believe that it has